Good morning, everyone. I am Dave McConus, and as the chair of the Built Environment Committee, it gives me great pleasure to welcome you all to our second digital event of the year. As an organization that prides itself in delivering content to our members, it has been great to see the almost seamless transition from a very physical, event-heavy calendar to one of pre-recorded content, webinars, and podcasts. Our annual industry update, in conjunction with Cornet, was published online in March, a link to which you can see on your screen, or you can get to via the BritCham website. And this represents our first webinar of many planned for 2020. The topic we're discussing today is the impact of COVID-19 on the construction industry and potential relief under the COVID-19 Temporary Measures Act. And as I was preparing an introduction, I wanted to stay away from the standard intros that you would have almost definitely heard already, as well as some of the buzzwords like new normal, universal disruptor. So in place of this, I will just share a few statistics with you. In January this year, the Building and Construction Authority predicted a total construction demand for 2020 to be in the range of $28 to $33 billion. In the first 3 months of this year, everything was going to plan, and we saw just shy of $7 billion of work completed in construction projects across the island, which was delivered in a large part by 323,000 foreign workers who reside in dormitories. Then from the 20th of April to the 4th of May, due to escalating numbers of positive COVID cases, foreign employees in the construction sector were put on a stay-at-home notice for 2 weeks. As of yesterday, Singapore had 29,712 cases in the foreign worker dormitories, which means if you took this group of people alone and compared them to the absolute number of cases to other countries in the world, they would be ranked 30th, with more cases than the entire country of Ireland. And on a per capita basis, they have more cases than anyone in the world. Needless to say, the healthcare and social challenge is immense. And in addition to this, the disruption to the built environment sector has led to many people asking questions about contracts and project delivery. Today, our two speakers will share with you the potential relief available in Singapore pursuant to the COVID-19 Temporary Measures Act, other key reliefs which are commonly available, and practical tips for managing the risks arising. Now, before I introduce our speakers, there are two housekeeping announcements. Firstly, if you would like to ask the questions, you can do by all means. You'll be able to find the question and answer function on a floating toolbar, and questions will be taken at the end of the session. And secondly, this session will be recorded and will be made available on the Chamber's website in the coming days. And with that, I'd like to introduce our two speakers from Clyde & Co. Firstly, we have Sean Hardy. As a projects and construction partner, Sean advises contractors and other project participants on project delivery and the resolution of disputes in the infrastructure and energy sectors. And joining him, we have Yvonne Fu. As a legal director in the projects and construction team, she has extensive experience in advising on construction-related disputes, including extensions of time and associated cost claims, liquidated damages, and termination. She also advises on the review, drafting, and negotiation of contracts for construction, infrastructure, and real estate projects. Sean, I'll hand over to you.
Yes, thanks, Dave, for the very kind introduction and some very sobering statistics there. So, and thank you everyone, of course, for joining. We hope you're all keeping relatively well in the circumstances. Dave has already summarized the content today, but I'll just add a few more observations. We're going to split the session into these three distinct sections. We've got the impact of COVID-19 on the industry, potential relief under the new Temporary Measures Act, and then thirdly, other potential relief under the contract or otherwise at law. I would just highlight these are all big topics. I'm also mindful that there's an awful lot of content out there, been a lot of media coverage about some of these. So really our aim is to try and wrap everything up at quite a high level, hopefully give you at least some food for thought, and I hope we can raise a few interesting points. So with that, we'll move on to the first section, the impact of COVID-19. And I'm going to hand over to Yvonne to set the scene a bit about the circuit breaker here in Singapore.
Thank you, Sean, and good morning all. Well, in Singapore, we entered this circuit breaker since the 7th of April 2020. The end date was shifted from the initial 4th of May to the 1st of June, which is just next week. During this period of circuit breaker, everyone was advised to stay at home, avoid going out except to buy food and essential items or for urgent medical needs. Most of the work premises were closed, and the essential services which were allowed to continue had to implement tight workplace measures to ensure, for example, safe distancing. For the construction industry, most of the projects were required to suspend. Exemptions for essential services applied to a handful of construction works only. For example, companies which were involved in epidemic control, selected development projects assessed to be in critical stages of construction and are unable to stop due to potential safety risks, and works in progress for critical public infrastructure, etc. During the suspension, only essential works were allowed to be carried on, and by now we would be quite familiar if you've been affected as well. These will include works only required for the maintenance, for the structural safety and integrity, maintenance of security, and, for example, environmental protection of project sites. We are aware that it was reported only 5% of the construction workforce continued working during the circuit breaker period. However, from next Tuesday onwards, Singapore will be exiting the circuit breaker in phase 1 of 3. This is what the government has called the safe reopening phase 1. For construction activities, another 5% of the construction workforce is expected to gradually resume work in the month of June, and projects that cannot be left idle for too long due to safety concerns, as well as critical and time-sensitive projects such as the MRT and deep tunnel sewage system tunneling projects, all these will gradually come online. However, all works will require BCA approval before they can restart, and migrant workers in the construction industry must still be tested before they return to work. On top of all these, adequate safe management measures will have to be put in place before work resumes. This actually then signifies to us that it will be a gradual exiting of the circuit breaker. And the impact on the built environment industry is that this COVID-19 will continue to be felt for some time before we're out of the woods. Now, Sean will now talk about some of the common difficulties and disruption that has been experienced across the board in the construction industry during the last few months. Sean?
Yeah, thanks, Yvonne. So if Yvonne was just looking at some of the specifics in Singapore, here I'm just going to try and wrap up some of the sort of the general principles. The general types of difficulty and disruption are certainly going to be felt in Singapore and are being felt, but also more broadly in other jurisdictions. Certainly, I think the first point is that there's a very wide range of different types of difficulty. They also kicked in at different times. We were talking about difficulties in procuring materials and plant, movement of labour, particularly out of China, right back at the start of the year. Sadly, with the spread of the pandemic, that's then become an absolutely a global issue, and one that's of course going to continue, at least for the medium term. Perhaps the second category, and Yvonne has touched on this in the Singapore context, but also applies, of course, to other countries, is the direct impact of these big interventions by government. We've had the shutdowns in Singapore, but of course, lots of other places. As Yvonne touches on, as we transition out of that, there's going to be all sorts of steps in place. Dave touched on the quarantine of workers in dormitories, but I mean, it's a very long list. I've just covered a few on that slide. Endless safe distancing measures, disinfection measures, health checks on site, staggered working hours, and so on. And they may well be with us for the long term, if not indefinitely. All are going to have an impact on progress and cost. And then perhaps thirdly, we've got the slightly more nebulous category of just the uncertainty for the future generally, the big concerns of a second wave of cases and possibly restrictions increasing again rather than decreasing, that's completely unknown at this stage. And finally, I'll talk a little bit about cash flow. I think that Singapore and other governments are keenly aware of the squeeze that this is going to put on all sorts of parties in the construction industry. I'll just come on in the next slide to a few steps that are being taken in Singapore. But an interesting point here, maybe slightly depressing, is that although it feels like the circuit breaker has been going on forever, it may well not be that it's until June that the full squeeze is felt by some, given the typical payment cycle in Singapore, with parties generally not getting paid until June for work they did in April when the shutdown and the circuit breaker started. So really just going back to Singapore, I won't go into too much detail here. This is just an extract from a BCA pamphlet. I've really just pulled it up to illustrate the very wide range of mechanisms that have been put in place to try and help parties and to help with cash flow. I'll just mention a few: foreign worker levies being waived in April and May, a one-off advance payment mechanism for contractors in public sector projects, and thirdly, no liability for non-performance of contracts, which is of course touching on that's a protection under the new Temporary Measures Act. So I think that brings us on quite neatly to section 2 of our talk and looking at that act. Before I pass over to Yvonne, I'll just make one sort of opening observation. At its highest level, this is a relatively unusual piece of legislation. In countries like Singapore and other common law jurisdictions, the principle of freedom of contract is fairly sacred. That is, parties are entitled to rely on the commercial deal they've struck in a contract without state or other interference. And this is an example of the state saying, in some circumstances, you cannot rely on your contracts and we're going to intervene, clearly with the intention of trying to help parties who are in trouble because of COVID-19. So I think that's the context. And Yvonne, now I'll hand over to you to talk a bit about the scope of the Act.
Thanks, Sean. And this Act that Sean has referred to is the Temporary Measures Act 2020, and a slew of related regulations has been passed. This Act was actually passed on the 7th of April 2020, and the relevant regulations for the construction and built environment sector would be that relates to the relief or inability to perform contracts. That came into effect on the 20th of April 2020 and would be effective for a prescribed period of 6 months until the 19th of October 2020. Now, before we delve further into it, let's just start by understanding the scope of this Temporary Measures Act in relation to construction-related matters especially. Now, the key test for protection under the Act is whether the inability to perform the contractual obligations was, to a material extent, caused by a COVID-19 event. So the COVID-19 event does not have to be the only cause, but it cannot just play a minor role in causing your default under the contract. The default has to be materially caused by the COVID-19 event. Then the next question would naturally be, what then is a COVID-19 event? This definition is broad and includes not just the virus itself, but also what is required to comply with COVID-19 related laws, whether within or outside of Singapore. The Act applies to construction and supply contracts as defined under the SOP Act, which is the Security of Payment Act in Singapore, as well as to performance bonds, amongst other things. Sean will come back to this in the next slide, so hang in there for a moment and hold that thought. And to go on about the scope of this Act, I will highlight some of the important dates that you've got to check in order to determine whether your particular circumstances fall under the scope for protection under this Act. The first is to ask yourself the question whether your agreement was made before the 25th of March 2020. And if so, you can potentially get protection under the Act. The next question is whether your inability to perform the contractual obligations arose after 1st of February 2020. And again, if that does fall under that bracket, you can potentially get protection up to the 19th of October 2020, which is the end of the prescribed 6-month period. Another important thing to do if you're seeking relief under this Act is to serve a notification for relief before the end of the prescribed period, which I'm now saying for the third time is currently 19 October 2020. It's important to keep the magical dates in mind, just so you know the extent of the protection that you may have under the Act. And also, it might be that you want to put a reminder in for the current deadlines in case you miss that, you might not be able to avail of the relief that's afforded under the Act. Now, this notification for relief has to be served in a prescribed form and by prescribed modes of service on the other parties in the contract. And if the relief relates to a performance bond, it has also to be provided to the issuer of the bond. I will not go into the finer details of the entire process of setting up the notification, but Sean will next explain the protection that you can obtain through this Act.
Thanks, Yvonne. So yes, the protection. Right, I've split it into two categories. The Act doesn't split it up that way, but I think it's helpful to look at it by thinking about temporary measures, the first category, and permanent measures. I'll come on to explain what I mean by that. But the temporary measures are so in place for the prescribed period, which Yvonne has mentioned. For the duration of that period, all legal, not all, but a large swathe of legal proceedings, including court, domestic arbitration, all sorts of winding up and other insolvency-related proceedings, cannot be commenced against a party who is protected under the Act. And to the extent there are existing proceedings of that nature, they're stayed. Importantly, it doesn't not included in that moratorium is SOP adjudication proceedings, so they can continue, although the enforcement of any determination does fall under this category, so that couldn't be pursued. International arbitration is not affected, nor is parts of court or domestic arbitration proceedings relating to other matters unrelated to the inability to perform because of COVID-19. And then secondly, in that period, cannot call on performance bonds or equivalent. And that's what the BCA guidelines and pamphlets would say. When you look at the Act, it's actually quite a lot more complicated than that. I won't go into too much detail, but essentially the protection is it can't be called, a performance bond can't be called until there are 7 days or less until the expiry of the bond. So a bond could still be called if there were 7 days or less. And then there's a mechanism there where if a party seeks to extend it, that there's a corresponding extension to the protection under the Act. Again, there are a number of detailed mechanisms in the Act, and that's one of them. Now, secondly, permanent measures. Permanent in the sense that although a party is protected from liquidated or other damages during the prescribed period and has a defence to claims for breach of contract, again in the prescribed period until 19th of October, they're permanent in the sense that in the future the party can always rely on those protections in terms of breaches and liquidated damages in that period. So fairly significant. And with that, I'm going to pass back to Yvonne to talk about this, another mechanism under the Act, and that's the assessor and an assessor's determination.
Yes, so This would be relevant in the circumstances when the recipient of your notice for relief disputes that you're entitled to relief for the matter described in the notification. Then the Act provides for a mechanism for an assessor to be appointed, and this assessor will then make a determination whether the Act applies to the particular set of circumstances. This process is designed to include a right of response within 5 days of receipt of the notification, and also a hearing, whether by way of exchange of emails or an online or physical hearing, whichever is considered necessary. The assessor will decide, and only decide, whether there is an inability to perform an obligation, and whether that is to a material extent caused by a COVID-19 event. What he's looking to do is to seek an outcome that is just and equitable in the circumstances of the case. So it can be expected that the process might be quite a broad approach might be taken in the entire process. It is important to note that this determination is final and can be relied on in subsequent proceedings. So care will have to be taken before deciding to challenge a notification or even to raise that notification for relief in the first place. With regard to this particular assessor mechanism, there will be no legal representation allowed before the assessors. So it's especially important for parties to be able to prepare and present clear evidence that any inability to perform was caused by the COVID-19 or not, depending on which side of the fence you're sitting on. And another thing to keep in mind is that while lawyers cannot represent parties before assessors, it's still possible to get assistance in gathering evidence and preparing submissions, but the cost will not be recoverable from the other side if you are successful in your application or in defending your application. The very last thing that I'll just highlight about this assessor's process is that there is no express provision regarding the confidentiality of the decisions made by assessors, but it is understood that any publication of the determinations would redact the identities of the parties. The aim of this might be to create a body of quasi-jurisprudence that can guide subsequent disputes on this issue so that there can be some level of certainty and or consistency in the dealing with such matters. So Sean is now going to go on and tell us a bit about tips that can be shared on the Temporary Measures Act.
Yes, thanks, Yvonne. And before I come on to some of our thoughts and tips on that, we're going to now launch a poll to get your input on a couple of issues. So if we could please launch the poll. So you should see two questions on your screen. There's just if you can please select one answer. So firstly, how helpful do you think the COVID-19 Temporary Measures Act will be for project participants in the construction industry? Not at all helpful, of some help, very helpful, or don't know. I would say there's no right answer to that one. The second is more really to gauge how well we've tried to summarize the Act. When a party is prevented from fulfilling its contractual obligations to a material extent by a COVID-19 event, so that's the test under the Act, that party is protected under the Act once it submits a notification under the Act, or only when an assessor under the Act determines that it is entitled to the protections. So, if I just give you a few more moments to select your answers. If we could now please close the poll and show the answers on the screen. Please bear with us. Here we are. So we have, for one, no, not at all helpful, 0%. The highest number is 60% of some help, 33% very helpful, 7% don't know. I think that, as I say, there is no right answer. I think that I probably would have said of some help, because really it's so fact specific, I think, and project specific. As I'll come on to, it could be in certain circumstances of enormous help. There are lots of other scenarios where it's going to be of limited or indeed possibly of no help. So that is very interesting. Question 2, we've got 33% party is protected once it submits a notification under the Act, and 67% only when an assessor under the Act determines that it is entitled. Now, the correct answer is in fact the first one, only once it submits a notification under the Act. So that doesn't reflect too well on our explanation, but in our defence, it is a really complicated process, and it's brand new, and frankly confusing on first blush. But actually you are protected, a party is protected as soon as it puts in the notification, hence the first answer being correct. It can be overturned by an assessor, but that protection is in place once the notification goes in. So I think if we can now just close if we can please close, thank you very much, we've closed the poll. So to wrap all that up with some practical tips, the first one is really just, it's re-emphasising that the key point, the key test under the Act, parties need to consider which obligations cannot be performed up and down the supply chain. So it could be that you're looking at multiple contracts on one project, depending where a party sits in the supply chain. Which obligations cannot be performed to a material extent as a result of a COVID-19 event, applying the test, and then you need to get a notification in order to have that protection. Perhaps a more interesting point, the second one, is notification actually advisable? And if so, when? And it's actually not an easy question. I think, as I touched on, there are certainly going to be some scenarios, perhaps where there's an imminent threat of a bond call or of winding up proceedings or other court proceedings to enforce a judgment or something like that, where the Act could be of enormous help in buying some time, at least for a party who is in big trouble. But if you put those sort of scenarios and those permanent protections around proceedings to one side, and I think this is reflected in everyone's answer to the poll question, the protection offered under the Act is fairly limited. And I think it's important to bear in mind that there are risks of a notification. Yvonne has touched on the process being brand new. Assessors are going to come from a variety of backgrounds. I think it's fair to say that at the very least there is a risk of inconsistent and possibly some bad decisions. So it's entirely possible that a notification could be counterproductive. Just one scenario might be if a party already has a brilliant defence to a claim under a contract, say a defence to a claim for liquidated damages, but it looks to rely on the Act as well, in addition, and then its notification's overturned, the counterparty might then use that adverse decision against it when arguing about the merits of what was otherwise a very good defence under the contract. So it could be counterproductive in some scenarios. And finally, the SOP Act is not impacted. I've already mentioned that, but I think it's important to note that although you can't enforce SOP determinations, the Act is live, adjudications are continuing. So everyone's got to be careful. All the normal advice about looking out for payment claims and so on continues to apply. And in fact, probably it's even more difficult now with office closures and so on. everyone does need to take care. So with that, I think we are ready to move on to the third section and the final section of our session, other relief under contract or at law. I'll pass over to Yvonne at a moment, but I'll just say that we're going to be looking at a few Singapore-specific contract forms, also one contract form that is used not so much in Singapore, but in the region, and that's the FIDIC Red Book. But having said that, we're keeping things at a high level, and a lot of these principles are of general application to all sorts of jurisdictions and indeed different laws. So with that, I'll pass back to you, Yvonne, to set the scene around these other types of potential relief.
Right. So when we think about potential relief that could be available, we could generally think about the types of basis on which relief can be sought. Is it a relief being sought at law, or is it a relief sought under the contract? For the lawyers among us here this morning, that's not, well, yeah, we know the differences. But for the rest of us who might think, what is the difference really? Now, contracts are subject to various applicable laws, and for the interpretation of contractual terms, construction projects in Singapore will typically stipulate Singapore laws as the governing law of the contract. There's no right or wrong answer to this, because you can stipulate any laws that parties agree on as the governing law of the contract. For today, we're just zooming in on Singapore laws. So a relief at law, at Singapore law, refers to a relief that you're able to avail as of right, as a matter of the law. Practically speaking, it means that this relief does not have to be written into your contract before you have a right to seek that relief. An example of this will be frustration of contracts, which Sean will delve into a little bit more shortly. On the other hand, relief under the contract will have to be provided for in the contract itself. A force majeure clause could be such an example in Singapore. There is no provision for force majeure under the law per se, no definition, no prescribed consequences. On the contrary, the law asks parties to look into their contracts to see what the contract itself says about force majeure. Again, we're going to delve a little bit more into this concept in a short while. Finishing up on the broad overview of the different types of potential relief available, the other question that we'll urge you to ask yourself when thinking about potential relief is, when looking at your options, what type of relief are you actually looking for? Do you want to get out of the contract altogether? Or if you are a contractor affected by COVID, you just need more time or more monies to complete the original contractual obligations. Depending on what you actually need, the different types of relief will suit in different circumstances. So that sort of sets the stage on the different types of potential relief, and we'll go into a few of these selected concepts to give you a bit more idea about how they actually work. Sean's going to start with frustration. So I'll hand it over back to Sean.
Thanks, Yvonne. So frustration. Just before I dive into that, just a reminder, please do ask any questions you have as we go along using the Q&A function on the toolbar. It could be anything about the specific issues we're raising, or more general questions. And as Dave said, we'll come back to those at the end. So frustration, I think the first point to note is that it's a really serious type of relief, in that the effect is parties are discharged from further obligations. So it's effectively bringing the contract to an end. It's also very rare. The supervening event has to be, well, it doesn't necessarily render performance of the contract impossible, but it must at least render performance radically different from that under the contract. That's a little bit legal, so perhaps a couple of examples. In the construction context, in fact, one of the leading English cases, Davis Contractors, is a construction case. And in that case, there was extreme delay on a project, or I think it was over 3 years, and a huge loss for the contractor. Now, that was not enough to frustrate the contract. So generally, the type of event that just delays everything, increases costs, even if that's quite extreme, you're unlikely to be in frustration territory. On the other hand, and the example on the slide, Wong Lai Yong and Chinachem, which was a tragic case in Hong Kong, where there was a massive landslip in the mid-levels, which crushed a construction site and tragically killed, I believe, 67 people. And it necessitated a complete redesign of the project. Now, that was enough. That was the original contract in that case was frustrated. So very rare. Something to bear in mind, though. Just one scenario, thinking of supply, for example, if as a result of COVID-19, perhaps some specialist machinery that say it's only produced in 1 or 2 factories in the world, those factories are closed or the manufacturer has been wound up or what have you because of COVID-19, you may then be in frustration territory if it's impossible for that supply contract to be performed. So something to bear in mind. Also to bear in mind, although it's certainly under Singapore, English and similar laws, it's available at law, so that's regardless of whether it's provided for in the contract. Should also carefully look for any contractual frustration clauses. We're going to look at a few of these different contract forms at a few points, but just to very briefly introduce them, we've got 3 that are Singapore specific: the bespoke LTA Land Transport Authority form, the public sector standard conditions of contract form of contract, and the Singapore Institute of Architects form of contract in Singapore. Finally, we've got FIDIC Red Book, which, as I said earlier, is of course used more broadly outside of Singapore. And in the LTA bespoke form of contract, at least some of them, you do have this contractual frustration clause. Slightly different, but in the FIDIC Red Book, there's an impossibility clause, has a similar effect of bringing the contract to an end. I won't go into the detail of that LTA clause, but arguably it is broader, in fact, than the common law doctrine, so helpful if you're intending to rely on it. And just certainly something to be aware of if you do have this sort of clause in a contract. And I'll touch on that at the end when we talk about practical considerations. And with that, we're going to move on to what's probably had the most attention in the context of COVID, certainly in legal circles, and that is force majeure. So I'll pass back to Yvonne now.
Yes, force majeure, potentially quite misunderstood, but another potential contractual relief in Singapore. Now, force majeure literally translates from French into superior force. So it's quite common to hear people use the phrase, oh, it's acts of God. Under the French Civil Code, which only recently defined it, it refers to an event beyond the control of parties, is not reasonably foreseeable, and which prevents performance of the contractual obligations. That applies if your contract is governed by French law. In France and in many civil law countries, it could be a potential relief at law. But in Singapore, force majeure is a creature of contract. What qualifies as a force majeure event? What are the consequences of a force majeure event arising? All boils down to what the contract itself actually says. There is a Singapore case of wholesome and precise development in the period of time where the sandban issues were abound. In that particular case, the Court of Appeal gave clarity to this matter Whether a party could rely on the force majeure clause in the contract depended on the precise language of the clause concerned. So what it means to us is what constitutes force majeure in one contract may not amount to force majeure in another contract. And turning to the next slide, we again see the 4 contracts which Sean has talked about earlier: the LTA, PSSCOC, SIA, which are local standard forms, as well as the FIDIC Red Book. We look into these standard form contracts to see if there is an express force majeure clause. And the results is that out of the 4, 3 of them contain express references to force majeure. Then we ask the next question whether there's a definition of force majeure in the contract. And the results are that only the FIDIC Red Book contains a definition per se of force majeure. What would that mean for us? Before you start worrying about it, it might be worthwhile actually checking whether the particular conditions or any amendments to the contract at hand, if it is one which refers to a force majeure event but has no definition, could be found in the other contractual documents defining force majeure. That could sometimes be the case. But if not, then the practical effects and impact of that in the context of Singapore law could be that there would be issues of interpretation in the event of a dispute between the parties. Now, turning back to the FIDIC example, where there is a definition for force majeure, we've set out part of that definition clause before you in the slide. And it basically provides that force majeure is an exceptional event or circumstance which is beyond a party's control, which such party could not reasonably have provided against before entering into the contract, which having arisen, such party could not reasonably have avoided or overcome, and which is not substantially attributable to the other party. This definition is followed by a non-exhaustive list of events which force majeure may include, but is not limited to. It is noteworthy that epidemics is not expressly included in this list. Then again, is this when you start worrying? Not necessarily, because the list is, as I've said, not an exhaustive list of all the force majeure events. So if you've got a FIDIC Red Book, 1999 edition, and you're looking at this particular definition, you've not got any amendments to this clause, all you have to look out for to determine whether your current circumstances affected by COVID falls within this is to ask yourself whether your event satisfies all 4 criteria of the definition. And if it does, it could arguably qualify as a force majeure event. We may expect some debate looking at the 4 criteria, whether COVID-19 could reasonably have been provided against before entering the contract. And that is in the context of having previous experience with other epidemics such as SARS or MERS. However, given the unprecedented extent of the impact of COVID-19, there is still some likelihood of success in arguing that COVID-19 could fall within this definition. From the last slide, you may recall that some contracts do not contain the words force majeure at all, but a rose by any other name would smell less sweet. So it's still not the time to start worrying, because there could be other clauses that still can be of help. And Sean's going to take us through some of these other alternative clauses to give you a flavor of what you could potentially find in your specific contracts.
Yeah, thanks, Yvonne. And I think Yvonne has really made the key point there. And that certainly under Singapore, English, other laws, actually whether you find the 2 words force majeure isn't determinative of the position under the contract. And you need to look carefully, because all sorts of other force majeure type events may well be provided for in the contract. And that's certainly the case if we look at the same three Singapore specific forms here. If you recall from an earlier slide, none have force majeure definitions, at least in the standard general conditions, but there are force majeure events, type events elsewhere. Perhaps two observations, and certainly this would apply just to contracts generally. The first is a huge range in terms of how many and the breadth of events which will be provided for. So in the LTA form, which doesn't have a force majeure definition either, pretty narrow. War, riot, or disorder in terms of these other events provided for elsewhere. PSCOC and SIA are far broader, and you've got all sorts of force majeure type events there: adverse weather, haze, natural disasters, and so on. And embargoes, which I won't go into, but has had some attention, could potentially be of assistance in respect of some difficulties arising from COVID-19, particularly in terms of any restrictions, perhaps, of supply from overseas, for example, because of a government's restriction. The second observation, this is very construction specific. You've got to carefully look at what protection a party has by reason of these events. And in the Singapore standard forms, certainly it's probably fair to say it's quite thin pickings for contractors, and generally they'll only be entitled to additional time and not money. So I think the final category we'll talk about is compliance with laws provisions. And I think when we're looking at the impact of the government interventions, the circuit breaker in Singapore, for example, this may well be the best home for delays and other impacts arising from COVID-19. Certainly if there's not otherwise a specific epidemic type protection expressly in the contract. And again, I think a few observations. They're very common, these compliance with laws provisions, but they do vary in scope a great deal. I won't go into too much detail, but again, pretty narrow in some LTA bespoke forms, limited to where the carrying out by a statutory authority pursuant of its statutory obligations causes delay. And then broader in the public sector form, compliance with the requirements of any law, arguably also laws of other states overseas, and various different provisions as well in SIA and FIDIC. And in fact, the SIA form helpfully provides expressly that shortage of labour, goods or materials from domestic or foreign government actions that could not reasonably have been foreseen would entitle a contractor to time. So very helpful there, potentially, under the SIA form. FIDIC, importantly, I think I did touch on this, quite broad, but also, and as distinct from most Singapore standard forms, the contractor is entitled to money on top of additional time where its work is delayed or disrupted, resulting from a change in the laws of the country, although in that case it is limited to the country as defined in the contract. Okay, so with that, we're on to our final slide. I see we've got one question that's come in. We'll come back to that. Please do raise any others that you may have in the Q&A section. This slide's really sort of trying to wrap everything up, and I'm going to pass back to Yvonne to talk about a few of these practical tips first.
Right, so we've mentioned some of these previously, but some, by way of summary, some practical tips to chew on would include, firstly, carefully reviewing your contracts up and down the supply chain. Ask yourself the questions: what are the specific problems faced in this contract? While COVID has been unfortunately lethal for some, it has been a defeatable virus for others. So the actual impact of COVID varies from one contract to another. Instead of just saying, my contract has been affected, you will need to know how your contract has been affected. And that will help you answer the next question that we'll urge you to ask yourself, which is, what are the relevant clauses in the contract? In identifying these clauses, you could shortlist clauses which describe the problems, such as a force majeure clause, or you could shortlist clauses which describe a desired relief, for example, a suspension clause. What is important, though, is that you read and understand the actual wording in the contract or seek assistance to do so. The other thing that we'll highlight is to work out how the helpful clauses that you've shortlisted could properly be invoked. Are there notice requirements? And if so, follow those requirements as strictly as you can. For example, setting out your notice in the prescribed format, submitting it within a set number of days, addressing it to the right persons, including information that is required to be provided. That is all important. And in most cases, it would be prudent to keep accurate, contemporaneous records of the issues that you're facing on your projects as you go along. The next thing that I'll mention is, given the far-reaching impact of COVID globally and how integrated the supply chain actually is, supply chain issues are a real risk in the built environment and construction industry. Being proactive to identify the potential bottlenecks based on the actual circumstances on the ground would allow alternative sources of supply to be explored timely wherever required. There are a couple more which Sean would want to talk about.
Yeah, thanks, Yvonne. This is quite a legal one, but just something to bear in mind. Everyone talks about notices, but you've got to remember also the duty to mitigate, which will be expressly provided for in the contracts we've just been looking for, but it's also a general principle at law. And that is that a party involved in a project does have to take steps to seek to mitigate, to minimize delay and costs arising. Reasonable steps have to be taken, and that can be a very difficult decision. It may be that switching suppliers, for example, is a necessary, reasonable step, even if the cost is higher, if that's mitigating much greater delay potentially and other project losses. Further particulars is another one. Although generally under contracts, you have to notify your entitlements, you then do have to provide details, normally within set time periods, and that can be extremely difficult in the current circumstances, given the complete uncertainty, for example, as to how long a delay event is going to continue for. But just something that has to be borne in mind. Second point is consider negotiation and alternative routes to relief. What I'm getting at there is that perhaps lawyers and others in the construction industry, certainly in Singapore, we're very used, perhaps we get a bit caught up in all the construction type entitlements, extension of time, and so on. And we have to remember that parties can agree whatever they want by consent. And certainly looking at the BCA guidelines, the government is optimistic that in these extreme circumstances, parties perhaps are going to be more collaborative, perhaps, than in normal times. And I, to some extent, would share that optimism. And just to remember that there's always the option of negotiating and potentially amending a contract by a supplemental agreement or whatever. And really in the same kind of point, just to bear in mind that the negotiating tools that might be available. We touched on frustration earlier, which is a very serious remedy. Contracts typically have other termination type mechanisms which may be in play. I think it's just important to be aware of all your options under a contract. If you're negotiating with someone else in the supply chain, it may well be that you want to say, I have this option, for example, a contractual frustration clause. I don't want to activate it. I want to find a way through this, but please do bear this in mind when you're considering my entitlements. So it can be useful negotiating tools. And finally, to carefully consider the risk allocation and approach under future contracts. I think this is an absolute can of worms. We get asked a lot of questions about this. It's very fact specific, but I would just say that broadly, of course, now is not an optimal time to be signing new contracts, but sometimes in some circumstances, it's unavoidable. I think a key point, of course, is that the allocation of risk in terms of COVID-19 has to be as clear as possible in any new contracts. But I think, unfortunately, and you've seen us grappling with some of the standard forms, that's actually quite difficult. The issue being that even if the allocation of risk was crystal clear in a draft contract, we're all in this situation where we just don't know the full extent, the duration of the impact of these COVID-19 type events, which does make it very difficult in terms of looking at new contracts. And with that, we've got a few minutes. I'm going to pull up. We've got one question which I will come to. Please do ask any others you may have using the Q&A function on the toolbar. I'm not sure if you've seen this, Yvonne. I'm happy to take it. Perhaps you could add anything. If I share, I think I'll just read it out. It's from Anthony. Thank you, Anthony. Is a claim against additional cost incurred arising from COVID-19, especially relating to new government advisories, justifiable? So to paraphrase that, can a party somewhere in the supply chain recover additional costs arising from these advisories? I can imagine one scenario might be advisories around safe distancing measures in terms of transporting labour, for example, dormitories. It's a really good question. Unfortunately, there's no simple answer generally, and it's going to depend on your specific contract and what entitlements you have in terms of claiming additional costs, which is what the question asks, as distinct from not being able to be sued or what have you under the Act. It's going to depend on your contract, whether you can claim that additional cost because of a change in law, for example, that we looked at. Unfortunately, generally in Singapore, from a contractor's perspective, most contracts will only provide for additional time, not cost, arising from changes in law, although query whether government advisory is in fact even a change in law. But I'm afraid it's one of those answers where it's really going to depend on your contract. Do you have any thoughts on that, Yvonne?
This is a dicey situation. And I agree with you, Sean. It is a matter of looking right into your contract to see what relief under the contract is available, because unfortunately, the Temporary Measures Act does not cover off this aspect expressly. The other thing that I probably would urge you to have a look at is the different resilience budgets and packages that have been declared by the government. So, for example, the job support scheme might be able to provide some relief with regard to foreign worker levies and costs in that regard. But otherwise, in terms of other disruption-like types of costs and expenses, it would really depend on what your particular contract provides for and whether you can find a hook in the contracts for you to make a claim that you can substantiate and get something back from your either employer or main contractor for. The other thing is really, Sean, reiterating what you've said just now about negotiating. In these circumstances, and especially in an environment like Singapore, I believe employers and main contractors alike are very much aware of the situation and the difficulties that everyone is in, and people are usually happy to pitch in to try to help each other out. So bringing it back to the other party that you have to negotiate with might sometimes yield positive results because they would try to help you as well. They've got an interest to get the project finished, so they would want to help you do that.
Yeah, thanks, Yvonne. Other than negotiation, not meaning to put you on the spot, but do you have any thoughts on other ways? If, say, Anthony in his contract, he doesn't have an express entitlement to additional cost, he's struggling to negotiate. Are there any other hooks in a contract he might want to look out for in terms of trying to get those costs back?
Are you thinking anything? Because it really, I mean, every contract differs.
Yeah.
So your loss and expense clauses in your PSS COC, for example, would be something that you're looking at. Variations, sometimes there might be a potential of asking for a variation from the employer or main contractor if, for example, they require you to procure from a different specific supplier, and that would increase the costs incurred in obtaining that supply from that alternative supplier. That could potentially be a variation. Then that could fall under the loss and expense clause, and you would be able to claim for additional costs in that way. But generally, Sean, if there's anything else that you're thinking about, would you want to share?
No, that's exactly what I had in mind. I just think it comes back to the key point of understanding your contract. You may get lucky, you may find a scenario where you can wedge these costs under an event in a contract. Suspension, for example, if you could argue that actually you could have restarted the works in terms of the government advisories, but an employer is reluctant for you to do so, you might be able to say this is effectively a suspension. And in the standard forms, you often do, from a contractor perspective, have an entitlement to cost for suspensions. But no, it's a very difficult one, and I think it just comes back, as I say, to understanding the full contract and working out what your options are. That is it, if negotiation isn't getting you anywhere. So with that, we're out of time, unless there are any other questions. I think I'm going to pass back to Dave. Thank you for listening, everyone.
Thank you very much.
Thank you.
That was great. Thank you very much for the presentation. We all really appreciate you taking the time to share this with us and answering some of the many questions that we all had in these unprecedented times. As many of the answers seem to be quite complex and specific, I'm sure if anyone has any follow-up questions, Sean and Yvonne, we have their contact details up on the screen. I'm sure they'd be happy to chat with you offline as well. For all of you who joined us, it's been a pleasure having you with us this morning. And please look out for more webinars and events that are coming your way. Sean, if you can just go to the next slide, we can share some of the upcoming events with you, and more can be found on the BritCham website. Finally, you will be receiving, in fact, I've just got mine in my inbox, the feedback form and survey for today's event. It would be great if you could spare a few minutes for us. And with that, we're out of time. Thank you to all, stay safe, and we hope to see you again at future events. Cheers.